Dear friends, today we will discuss another interesting topic, that is Section 9 of IBC, Insolvency and Bankruptcy Code 2016. Suppose you are a supplier of goods or services which are required to run operations of the buying company. You have given supplies and the outstanding amount is Rs.1 Crore or more. Further, the outstanding amount is not disputed, yet the company has been delaying your payment. Under such a situation, what will you do to recover the dues? You see, civil suit for recovery is a long drawn process, whereas IBC provides a much faster and economical solution. So let us try to understand what one has to do under IBC. You see, Section 8 of IBC requires the supplier to serve a notice upon the company for payment of the dues, and the company is supposed to reply within 10 days saying that the payment has already been made and furnish the payment particulars, or say that there has been an existing dispute prior to the date of the notice, hence the payment cannot be released. Otherwise, the seller will be entitled to take buyer to NCLT under Section 9 of IBC. Please note that in case there is a pre-existing dispute about the claimed outstanding amount, the NCLT will not admit the company for CIRP, that is Corporate Insolvency Resolution Process. What is pre-existing dispute has been a matter of debate before various courts. Recently, in the matter of Rajratan Babulal Agrawal versus Solar Tax India Private Limited and others, Honorable Court has thrown some light on this contentious issue. Let us discuss facts of this particular case. You see, there was a contract to supply Indonesian coal which was to be used for boilers. Broad specifications of coal were agreed upon by the supplier and buyer. The seller supplied the coal. Lab reports indicated some deviation from stipulated parameters, yet the supply was accepted and the material was consumed. While consuming the coal, the boiler's nozzle developed some choking problem, etc., resulting in a loss to the buyer, which was informed to the supplier. The supplier was further informed that in case the loss is bound further due to inappropriate quality of coal supplied, appropriate amount will be recovered from them. The supplier was advised not to supply material further. However, the company did not file any recovery suit for the damages at this stage, rather until the demand notice was served upon the buyer for the payment. On receiving demand notice for the outstanding amount, the buyer not only replied to the notice but filed a counter claim as well. The issue before the Honorable Supreme Court was like whether under the facts and circumstances of the case, where the buyer has accepted the delivery, consumed the supply and raised no demand for the damages except writing an email sounding the supplier of the losses being incurred due to inferior quality of coal, whether the buyer can take a stand before NCLT and say that a dispute has been existing, hence it cannot be dragged to NCLT. The points considered by Supreme Court in this regard revolved around these points: whether like this Sales of Goods Act says that a stipulation in a contract of sale with reference to goods may be a condition or a warranty. A condition is a stipulation essential to main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. Whereas a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not a right to reject the goods and treat the contract as repudiated. As the buyer has accepted delivery of the supply, hence the condition about the quality has been treated as warranty in this particular case. Where a condition is treated as a warranty, the buyer may claim for reduction in price and or claim damages for breach of warranty. As the buyer had raised a dispute about the quality and did not give up the right to file a suit for the damages, the court, considering the fact that the buyer filed a suit within a limitation period for recovering the damages, the dispute was pre-existing, hence allowed the appeal of the buyer, that is corporate debtor. Thank you so much.